this person cannot make good decisions. They're vulnerable. They're vulnerable to influence. They're vulnerable to things that people tell them. And we all know that. We all would agree with that. But yet we all would also agree probably with the judge in saying that we want to be very slow of taking away someone's capacity that makes them a human being, in saying they can't choose marriage, they can't choose divorce, they can't choose anything in their lives, they can't choose where they live. They're going to live at the instruction of another human being.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. Today we're picking up with the life of John Amos. Now, the previous episode, we talked about his early life, his career, his family, his children, grandchildren. We talked about all that. It's not essential that you go back to that in order to make sense of what we're going to cover today, but it may be helpful. But do as you wish. But going forward today, we want to talk about what in fact transpired during that last third, during the final third of his life, that period when, you want to have your planning such that you can live your best during that period, and then be sure that as you leave this world, that the things that you've accumulated in this world go to the purposes that you want them to go to, which is typically those you care most about. In this case, we have a complicated picture. We've talked about how John Amos was not, as some celebrities have been, who we've talked about, very dissolute and even debauched, for lack of a better word. Just a lot of bad decisions so often among celebrities, multiple divorces, substance addictions, lots of affairs, and women outside marriage through whom many assets disappear or consumed.
He was kind of boring on that side of things, but not a boring man at all. I mean, he had two ex-wives, one for 10 years marriage, the second one was 1 year, and he had two children, fully related to each other, had the same mom, same dad, and it was from the first marriage. Pretty simple.
Yeah,
right?
I mean, he definitely handled things in a responsible way. That's probably the best way to put it, in a very responsible way. But he could have done better, and you'll see why as we go through this. So John, he didn't die until actually last year, 2024. He had heart disease for some time, and so the cause of death is listed as cardiac failure, I think. So nothing suspicious there as far as the death itself. During the last 10, 15 years of his life, he continued to work some, not a lot. It was spotty, but he had an appearance as late as 2022, I think, in a movie of
Coming to America too.
I
think he was in that one. That was I can't remember what year that was.
Was that late? No.
He was part of that.
That wasn't 22, was it? No.
It was in the 20s.
Anyway,
I'm almost positive.
Okay. So I know that, so maybe that's what I'm thinking of. I know that he was in a movie very late. Now, what makes that interesting is around 2016, he was diagnosed as having Alzheimer's. And what is the other form of that or a type of it?
Yes, there was one that I had not, it's part of dementia.
Something body.
Lewy body?
Lewy body. I think it was Lewy body syndrome. So anyway, it did not debilitate him immediately. So there's some dispute as to the pace at which he declined. And I think the fact that he could be in a movie, if he had many lines at all, I didn't see this movie, but I mean, at 22, that's kind of prima facie evidence that he wasn't, quote unquote, what the law would call incompetent. When you're incompetent, then any decision you make legally would be invalid. Any influence that somebody had over you would be deemed probably to be in a position to exercise undue influence. So there's all sorts of implications of someone becoming what the law would consider incompetent. But you're not officially incompetent until you're found to be that, till a gavel goes down. So the question of whether you were or not outside that is going to determine the extent to which somebody may have unfairly or fraudulently manipulated you. So in this case, we have these two children, and remember there are two grandkids, and the two grandkids are of the same parent, and that parent is Shannon, the daughter. So son and daughter. The son is KC. So KC apparently was with his dad more in those final years. If we listen to Shannon, Shannon says that's by design. He, in conjunction with two others who were living there at the time, one supposedly helped to manage his publicity or promotion at one point. What was her name?
Belinda Foster?
Belinda Foster, we believe, was that name. Mm-hmm. We're not saying she's guilty of this. Keep in mind, this is just what Shannon has alleged. And then there was another guy there who was a caregiver.
Eugene Brummett?
Eugene Brummett. So, again, we're just reading reports, so we don't know, in fact, what is true here. But we're reporting to you what Shannon alleges is the case. And Shannon has complained loudly and broadly, including filing reports with the Family Services of California, alleging that there needs to be protective care and that there needs to be a home check that to be done. And this is in 23 with her dad. So she felt that she was denied access, and that this was through the efforts of her brother, KC, and those also who she would allege were acting in conjunction with him to exploit their dad and to be able to change estate planning documents, including a will and a trust and powers of attorney, et cetera. So these are allegations. Again, we don't know if they're true, but we do know that the conflict happened and that has wound its way through the court system. And as it stands right now, we know that there were pleadings that were filed just recently in which I'm sure it was Shannon's lawyer that filed a document with the court, which was attached the original will and trust. By original, I mean it goes back to 2020. And during that time, while it's after 16, so one might say, well, we had a diagnosis of Alzheimer's in 2016. Does that mean there was capacity at that agent or at that point? And I think there was, by all indications. Mm-hmm. He was doing some other professional work at that time. Again, not a lot, but he was sufficient to suggest that he was functional. And also, I think what is significant is in the pleadings that were created, or the estate planning documents that were created in 2020, were actually signed as witnessed by the kids. So the kids apparently both, and this is not just KC, this is Shannon too. Shannon and KC both were apparently present when these documents were signed with a lawyer there. I'm betting in a lawyer's office. I hope it was, meaning I hope that they didn't do this at the kitchen table among themselves. It didn't look like that. Yeah. However, the documents did say wills and trusts. So I'm not sure that's attributable to the website that these were ordered online. I just don't know. It's possible that these were ordered online. Assuming that website was around at the time, and I don't want to be in a position of promoting, a website to do documents online for estate planning. But anyway, it may be that this was something that was acquired by they themselves, including the dad, and that they did this. But it was signed and it was completed in what appears to be a lawful way. There was a notary that had notarized it. And you had the two witnesses that's required by law in the state of California. You had the signature of the testator, and as to the trustor. So these documents, I'm just wondering why they were just filed recently. And they were just filed in the state of California this year. I think it was in July. So I had one of the lawyers from one of our offices in California to go and to get what they could. And so what I was sent was these documents. And I've looked at them, and they appear to be very fair. John clearly had in mind, John Amos wanted to treat equally his two children and his two grandkids.
Yeah, he listed all four of them.
Yeah,
and when you
equally.
list all four, okay, I was going to ask you that. When you list all four,
you want them to be on the same tier.
Okay, on the same everything.
Yeah. So the way that distribution goes when you have somebody that dies is often the grandkids will take the portion that would have gone to their parent.
Okay.
So it's a little unusual to do it this way, where you list all four on the same line, so to speak, and they each would get 25%. But That's a very reasonable idea. And these were adults. Incidentally, the grandkids were adults. So he came up with a plan that I thought reflected wisdom and the fact that he wanted everybody treated the same that was closest to him. And apparently his grandkids were very close to him.
And I love that he was even thinking about his pet. Because that is
Yeah,
even
that's
listed
right.
in there. I was like, I've never seen that before, the pet caregiver. And he had a backup caregiver for the pet, too.
Yeah, that you're right. He did have this was fairly thorough. Now, it was a form, so it triggered you to think about each of these topics. But, a good lawyer should be doing that as well. And he filled this out. He signed it. It seemed reasonable. It was a pour-over will, which a pour-over will, as we've talked in this show before, is where really you want all your assets to be in a trust. And the way life works is you often don't actually put stuff in the name of the trust in the give and take and activity of life. So you often will die with things that are just in your name or your and your wife's name, whatever. But the point is, in order for it to get into your trust, it needs to go through probate. That's not the best solution, but it's better than if you didn't have that at all, trust for it to go into, and it just went into probate. So in his case, he wisely created a pour-over will. The pour-over will said, anything that goes into my probate estate, I want you to put it into my trust. And then he created a revocable living trust, named himself as the initial trustee, named the successor trustee. Remember, the successor trustee are the people who you want to take over when you become incompetent. So the moment, or die, whichever comes first. And sometimes you'll have two people on that line. That's not unusual. We've talked a lot on this show how often it's an intelligent thing to do, but you need to be careful about who you put on there and that you don't invite the sort of conflict that brings to a standstill the very things that you were most concerned about getting done very efficiently. So often a solution is to have an individual and maybe an institutional trustee. Institutional trustees tend to be professional enough to where they know that they don't want to hold up important decisions. So oddly enough, they often move more quickly than siblings who may not always agree on things.
Yeah, because they're not thinking with their heart.
Yeah, right. They're not thinking with their heart.
It's in the way.
It's a good way to put it. They know what the instructions are, and they ask themselves, well, is this the proper thing to do? And if it's yes, they go with it. So in this case, the two siblings were named, and fallback was grandkids, not surprisingly. I mean, he's really treating them like children. But somewhere along the way, this plan apparently got changed. So I have to confess that though I'm doing this show for you today, I haven't been able to check the records of Colorado. We have offices in Colorado, but our lawyers have been in trial, and so I haven't been able to get somebody to do the research. So there are some unanswered questions for me, but I don't think these have to be answered for our purposes on this show. I'd like to have answers. I'd like to know, were these documents that I just described to you that called for all the assets to be distributed equally among the four, that was a pour-over will, a simple pour-over will, a pretty simple and straightforward revocable trust, very reasonable, provided for John to be in charge of his life as he should be up until the point where he becomes incompetent. When he becomes incompetent, for the kids to jointly take over to make those decisions. That was a reasonable plan, I think. It depends on what did John know. Did John have reason to know that this could go the way it went? And that's something we don't know. But when we're standing on the outside critiquing, it's kind of our purpose in a constructive way. We're critiquing the decisions he made. It's fair to ask, did he have reason to know that this was going to result in the sort of sibling conflict that will never heal? I mean, I can tell you that based on what had been said by both sides, including the grandkids getting in it, I don't think this is going to heal. But anyway, he made a choice that on its surface is not crazy. However, after it was implemented, apparently I think we can safely assume John continued to decline, what you expect. I mean, it's a degenerative disease. Yeah. So he continued to decline. And over the course of that decline, it seems that one child positioned himself, KC, better than the other to care for him. And Shannon would say positioned himself in complicity and conspired with these other two people to be able to make decisions. So among the things that should have been executed and were executed in 2020 were durable powers of attorney, a durable power of attorney for health care. So all the things that would enable two well-intentioned, reasonable children to be able to act jointly, to minimize court involvement, to be able to get their dad into any sort of institution that he might need for care should those sort of circumstances arise, that might be able to get medical procedures done without any delay, because you have these documents that allow things to move along quickly, and a provision that in the event that he does become incompetent, other things can be taken care of for him. So the whole, the package was completed when I look at what was provided to me from this, I think it was November 2020.
Yes.
There was this package that on its face looked adequate, but yet we know that somewhere along the way, some of these documents were supposedly replaced. And you can replace a durable power of attorney. It's not as if you have to have the person who you've appointed to be the quote-unquote attorney in fact. It's not as if they have to voluntarily resign. You can fire them. And so if you want to appoint somebody else, you create a new power of attorney. You have an obligation of the statute to try to let them know that you've done that, so that they don't inadvertently act on your behalf and do things that would still bind the person who had granted the power, their dad. So apart from that, there's not an obstacle to getting, to essentially pushing Shannon out and getting the son in charge. But to the extent dad is incompetent, this would be considered overreach. From a legal standpoint, it may even be financial exploitation of an elder person. It can be considered elder abuse. These are both statutes that exist in California, and they're vigorously enforced. So California is not one to neglect allegations where there's an allegation of this sort of exploitation, physical or financial, and there are criminal consequences. So these causes of action can be criminal. They can be pursued on the basis of a civil action, or just remedial, meaning to get them into the proper care of others. And often that's done through the probate court. That's why you'll sometimes hear of actions being filed to have somebody declared incompetent. And maybe that's what should have happened here, was that as soon as Shannon was hearing or was persuaded that these things were happening, if in fact they were, then her remedy would have been to bring an action in probate court to say that her father is incompetent and ask for the appointment of a guardian and a conservator. The guardian is the person whose responsibility it is to take care of the physical person, and the conservator's job is to take care of all the financial aspects and the business, sort of things of people's lives. So in this case, I think she actually may have tried to do that. And here's the problem. Often when you bring that action, the person you're trying to protect, they may be incompetent and still resent, still oppose you and work against you, and maybe even in conjunction with another child, defeat your action. And I don't know what happened in this way, but it's clear that there was a petition filed. Let me go down here and look.
Well, and two, they had a hard time, Shannon, finding her dad, because KC allegedly was keeping dad from the family and friends, and they were moving quite often.
Yeah, and you're right. That was a problem too. And again, we're hearing this from Shannon, but Shannon is so passionate about this. It's hard to believe that she has manufactured or fabricated all this. It seems to me that there's some truth in what she's saying, but again, none of us really know. But I have listened to her interviews, and I couldn't find a counter interview by KC. But it could be that KC's just following the advice of his lawyer. His lawyer may be saying, look, let's not try this in the court of public opinion. Let's keep this before the judge. So here's what I know about what has been filed to date. Apart from what I just mentioned to you, was filed in July of this year, and that was this will, pour-over will, and the trust that was created in November 2020. Why would this be filed today? I'm really baffled about this chain of events. But then, as I was reading about the additional litigation, it appears that there are other documents that were created after that date that perhaps have been proffered to the court before this as the actual estate planning documents. So anyway, June 8th, 23, Shannon, she publicly alleges elder abuse against her father. She even launches a GoFundMe. So that raises kind of the financial question. Apparently, there weren't many assets. We can argue whether it was a couple million in value, which would be attributable to some residual intellectual property. I can't imagine there's a lot, but there could be some. It's not like, again, often people who write hit songs or bands who perform hit songs and wrote. And so we'll have this, this substantial amount of intellectual property out there. And you can have it also through name, image, likeness too. So there's some name, image, likeness, certainly. So that it's not that there's not intellectual property for John Amos. There's not that there is for not as much as that we commonly see when we do, some of the celebrities on the show. But it is some. But I don't want you to think that somebody like John Amos, people who are very talented, they're good, they were in a number of things, but by they were not grade A actors and maybe were not regularly employed even as a B-level actor. Still, it's not realistic to expect them to be able to live well in their revenues, even though we know their name, they were on shows.
Yeah, but it was shows in the 70s, so laws and things have changed.
It might have gotten better
too. Mm-hmm. For the residuals and any kind of contract negotiations and things like that.
No, I think you're right. I do think it has gotten better. So we have this litigation that was filed, the GoFundMe, and then July 2023, apparently Casey was arrested for allegedly threatening Shannon, which has escalated the family conflict. 2023, I don't have a month on this, when John Amos was actually hospitalized, but apparently he was hospitalized multiple times for various infections.
And I did see, too, that there's some allegations by Shannon, including with the elder abuse, that Belinda, that we had mentioned before, Belinda Foster, had told doctors that she was John's daughter. And didn't take him to the doctor until it was too late, right before he passed. And I saw that in the Hollywood Reporter. So. Well,
no, and some of these, when we do the research for this show, we try to use the best sources we can, but some things are not to be found in courts. I mean, they're not to be found in court files and courthouses. They're often research done by TMZ or some of these sources that, sometimes get it right, but not always. So I'm always careful in accepting the facts we present to you as conclusive. So I'd like to make clear that there's, I haven't been able to get fully access. I don't find KC making his side of the argument the way I would expect. But again, it could be because his lawyer's saying he shouldn't. So you're right about the Adult Protective Services. They were called in because of this suspicion that he was hospitalized multiple times, and this was relating to some sort of infections that were recurrent, and it suggested that perhaps he wasn't getting the medication that was prescribed was not being properly administered. Otherwise, this infection should have gone away, and instead it keeps recurring. So there was the investigation. We know that there was this arrest. I don't know that there was a finding of elder abuse against KC. I didn't see that anywhere. So we do see where Shannon files this lawsuit in the probate court, and I'm sure in conjunction with that, she's filed the documents that I mentioned to you a few moments ago. But her allegation was that there are floating around these numerous revisions, and numerous, I don't know what that means, but to hear them talk about it's like every few days.
They were adding something else.
There's new estate planning. So I don't know how frequently that occurred. Apparently at least several times. Yeah. And again, this is Shannon, but she sounds credible. She argues that she asked her uncle to intervene to try to get KC to promise to not put any more estate planning documents under the nose of his dad with severe, at that point, Alzheimer's.
Yeah.
It sounds outrageous to me, and again, we're on the outside, but if there were changes made after 20, now remember his diagnosis was 16, 20 we can accept that, okay, he probably was competent. Remember, competent's a low bar, so he probably was competent. Do I think he was competent in 22, 23, 20? I don't think so. I mean, I could find it very credible that he was not. That's not the time that you'd be wanting to do a lot of changes in your estate planning. And especially if it's doing something that seems inconsistent with what John's position had been his whole life, which was equal. He wanted to treat all of his loved ones, including his grandchildren, equally. So that is the sort of perspective that we know existed when he was in his best state. And for him to have, in the final years with Alzheimer's, come up with a new plan, that would be greeted with suspicion.
Yeah.
I would think.
Definitely.
That's where, if you're doing that sort of planning, you need to, his lawyer should have it videotaped. There should have been an evaluation done to prove that he was competent and documented. So in other words, to set the stage for what is going to come later. But in this case, there's not the sort of estate underlying this to where you would expect it. Often you can expect it when there's 10, 20, 30 million, 5 million. But here, I think we were below $1 million in assets at this point. The intellectual property clearly has some value, mainly in name, image, likeness. But I can believe that net assets were probably below $1 million and maybe as low as $300,000. Now, as to whether there's dissipation by KC and these others having the access they did and the opportunities that they did, maybe. It may very well be true that there was. We just don't know. But I can see why Shannon is concerned about this. So the way things stand is that the lawsuits are such as they are, seem to be pending. I don't know where the estate action is going to end up. I think that the cause of action that is a civil action where it's related to fraud, undue process, and exploitation. That civil case probably going to be around a while. As to the state's case, that probably has been resolved either by finding or no finding. We don't know. One thing to keep in mind, I'll say this real quickly as I wrap up here, is whenever you're deciding who to put in charge of your estate planning, I mean, you have to allow for the possibility that there's going to be that undue influence, that coercion, fraud. Those things can simply happen. So when you yourself are planning for the end of your life, you need to do that at a time when you can build the sort of fortifications that you need against that sort of potential. And you cannot assume that there's going to be this angelic relationship among your children. You can predict more for some kids than others, but you have to allow for that possibility. And whenever you're setting people up to make decisions at a time when you're simply you're there for the ride, you're not in a position to control things, and it's under those conditions that you have to worry most about. Can I be confident that the plans that I have in place, not just for the balance of my life, but for the ones that I care most about, the balance of their lives? So that's where it often is good to have a disinterested third party, somebody who is in a position legally to say stop if something is out of line or questionable. They're the ones who are going to have the lawyers. They're going to know the law. They're going to have manager professionals who are going to be concerned about the implications of making a bad decision. Whereas when you have an individual like now, where we'll assume it's KC, but it could be a couple others, we don't know what went on in that house. So there's some speculation that's required. And whenever you set yourself up for care under those circumstances, then it may not always go well. But yet we all want to believe we can trust our children. And I'm not suggesting to you that you should never trust your children. Some people say, whatever happens, I want my 2 children or 3 children to make the decisions. And that may be perfectly wise. But it may be. But again, you're betting on the potential for conflict. And but I don't want to speak against that. To be honest with you, that's my own perspective with my own 2 kids. So it's not that it's bad. It's just that those of us who do this, if we do this, we have to do it with some sort of disinterested assessment. We have to be able to step back for a minute and say, now, is this rational? And for some of us, it will be rational to go forward. For John, it could have been rational. It could have been there was no way he could have foreseen. There was no precedent for this sort of conflict. But I suspect there was precedent. And John was just probably a hopeful guy.
Yeah.
And he,
maybe thought that the kids would, no matter what, would end up working it out. Maybe this would bring them closer together somehow instead of kind of pulling them apart.
Well, and that could have happened. I mean, so I think that all in all, when we look at the life of John Amos, in a way, this is a very positive life to assess because he's closer to a normal situation. His finances were limited in final years. He had a home that was foreclosed on, but apparently it's not as bad as it sounds. Apparently this is a house that he had lived in for a number of years. He had already moved into another place and they were trying to sell it, but the house had gotten real run down. And I think the foreclosure occurred in 22, I believe. So at first it sounds maybe like he was destitute. I don't think he was destitute. I think he had another house that, according to these documents that were filed with the court this year, the ones I was describing to you, the lawyer representing Shannon who filed these, the lawyer stated on the information sheet, which is at the front of the pleading, that the estimated value of the estate was like $500,000, and the house that he owned at the time of his death was worth $300 and had $150 million debt on it. So I don't think he was broke, but I think that he had to live frugally, and I think that he didn't have the sort of attention that often celebrities have and that none of us can expect to have. And so these things often play themselves out, in almost in anonymity across America, where older people, because of family conflict or, a bad apple in the family who's inside because they're a child, you have those. You have that.
Well, and money can really bring out some mean in people.
It does.
Too.
And so it's good. It's all the more important for us to think about cases like this where things can go wrong we all can be sure that John Amos would not have wanted what's happening now to happen. And the grandchildren to even be pulled in. So there's a cautionary tale here for us. I want to congratulate John for the fact that he did estate planning. He did it at a time when clearly he was competent. He should have done it much earlier, but maybe there was something earlier. But the earliest documents that I found were the ones from 2020. But I think he was clearly competent at that point, and his plan was reasonable. I think though that his choice of executors and his choice of trustees and the people to whom he granted the durable powers of attorney, namely his kids, and as we've talked here the last 15 minutes, that's where things went sideways, but we can't say that it was a crazy plan. What we have to do is keep in mind, though, that when we're doing our own, we need to stress test it. Imagine what would happen if there were conflict. Do you have a solution? And there are a number of solutions you can write into your plan. You can have somebody who has a trust protector. It's called different things in different states, but it's equivalent of somebody who has authority when they see two trustees doing something that's not right or that just creates conflict so that things come to a stop, there's an impasse. That person, called a trust protector in most states, this trust protector can step in and fix it. They have the authority to do the right thing. In this case, if there were a trust protector, that might have fixed it. One thing, though, that you can't fix is when a person is in that wide gray space between, on the one hand, clear incompetence, where if you put them into an incompetency hearing, if you brought that before a court, the court clearly is going to bring the gavel down and say, yes, the court's going to appoint somebody to run these things, and they're going to report to me regularly. There's that extreme or that end of this spectrum. There's the other end of the spectrum where the person is perfectly clear, right? They can make their own decisions. There's no judge in the world that would bring the gavel down and say they're incompetent and they lose their ability to make decisions about their life. My point is that if you regard this as a spectrum, there's this wide area in the middle that's gray. And in that gray area, judges are reluctant to say somebody is so bad that they lose their right to govern their lives. But yet, though a judge isn't willing to do that on this extreme, you have this substantial area in the middle where any of us would say, this person cannot make good decisions. They're vulnerable. Mm-hmm. They're vulnerable to influence. They're vulnerable to things that people tell them. They can't be entrusted with their own lives. And we all know that. We all would agree with that. But yet we all would also agree probably with the judge in saying that we want to be very slow of taking away someone's capacity that makes them a human being, and saying they can't choose marriage, they can't choose divorce, they can't choose anything in their lives, they can't choose where they live. They're going to live at the instruction of another human being. So judges are appropriately loath to take that action. So that's the problem here, is he probably hadn't gotten to that point when many of these things were occurring. These transactions that are alleged to have been made, they would have been made in the privacy of his home perhaps, we don't know, but it's difficult to find a solution in that scenario because of this gray zone between a court's intervention and not. But now again, if somebody, even without being incompetent, just to be clear, the final point we're wrapping up, even before someone is incompetent, if there's exploitation, that's what these laws are designed to address. So despite everything I just said, there is still a remedy if you can prove that a caregiver under the statute, anyone can be a caregiver, someone who's in a dependent or trusted position. It can be a family member, it can be somebody who's paid to provide care. But there is a presumption of influence for people in that position. So if certain actions are taken in their favor, there's a presumption against them that they were guilty of some sort of undue influence or some impropriety, and it's up to them to establish, to overcome this presumption. So there are protective laws out there, let me be clear, to protect someone before they go over into that zone. Now, these same laws apply to them when they're in that zone of incompetence, but these laws would apply when they're not in that zone, just where they're very vulnerable and trusting. It's called a dependent person. So not necessarily somebody who is completely incompetent, a dependent person. Usually old, doesn't have to be. Normally it applies to elders is 65 and older under statute. So in this case, I want you to know that there are remedies there, but you still are depending on a state agency to come in or some other official to come in and be able to establish that these things occurred. And it just gets murky. It gets murky. So it's better to not go there. It's better to be able to preempt these problems. And in this case, I guess for various reasons, it didn't happen. So, all right, with that, I hope this has been interesting and helpful to you. This has been another episode of Life's Third Act. Remember to click us as favorites, subscribe to the channel, and also contact a Cordell & Cordell office wherever you are. We offer estate planning services. Cordell & Cordell has an estate planning group, and we're in many cities across the country. So I encourage you to call. And I'll add one other thing. If you tell them that you heard about this on the show, you'll get a 15% reduction in your fee. That's substantial, 15% reduction. And it's not something we hand out casually. Lawyers generally don't hand that sort of thing out casually, but we really want to know that people are watching this show and benefiting from it. So we're going to keep this on for a while. So remember to mention, if you heard about it on here, when you call to make an appointment, mention that and they'll give you the 15% discount. So till next time, this has been another episode of Life's Third Act. Take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.